Hello everyone. Today's newsletter is what to remember when your deal doesn't close. When your deal doesn't close, there are 5 important lessons to remember to make sure that you gather the correct information to understand the rights both of your client and your brokerage when the deal doesn't close. Here they are. Number 1, the buyer can't close because they don't have the financing. This is happening more often than you think. Firstly, you want to try to save the deal. See if there's any way to negotiate an extension for the buyer to perhaps either get more of a down payment or perhaps seek alternative financing. If the buyer cannot close at all, the seller has options. The main one is that he can sue the buyer for the deposit and for any deficiency if the house sells for less money. So for example, let's say the sale price was $300,000, deposit of $5,000. The buyer doesn't close. Now the seller resells the house for $280,000. The seller can sue for that $5,000 deposit plus the additional $15,000 that was lost on the resale. Even if the seller resells for a profit, they could still sue the buyer for the deposit. Number 2, let's say the seller and buyer sign a mutual release and ask you to return the deposit to the buyer. In this situation, the brokerage must return the deposit to the buyer. The seller cannot sue the buyer because they have given a mutual release. That is the effect of signing a mutual release. Number 3, let's say the deal couldn't close because there was a problem on title or a tenant that did not vacate in time for closing. In this situation, the seller will likely not be able to sue the buyer for anything because it was the seller's fault that the deal didn't close. In this situation, the brokerage may be able to sue the seller for commission. Number 4, as a listing brokerage, what should you obtain when the deal doesn't close before relisting the property? Well, the easiest answer is a mutual release. So if the buyer and seller sign a mutual release, you can immediately relist the property. However, if the deal didn't close because the buyer was in breach, you're not going to get a mutual release. In that case, you're going to wait for written instructions from the seller lawyer telling you to relist the property. As long as you have those written instructions, you can relist the property on behalf of the seller. Number 5, is the listing brokerage required to also sign any mutual release? There is no requirement for the listing brokerage to sign the mutual release. However, if the buyer and seller have signed it and have directed that the deposit be paid to either the buyer or the seller, the listing brokerage must follow those instructions, whether or not they have signed the mutual release. Remember, as a listing brokerage, if you sign the mutual release, you are not able to sue anyone for commission. A benefit to signing a mutual release is that now both the buyer and the seller also release the brokerage from any future claim. Before making any decision about signing a mutual release, you may want to seek legal advice first. By understanding what happens when deals don't close, it is hoped that you can ask the right questions and get the right information to protect both your clients and yourself. If you have any questions about these topics or related topics, please don't hesitate to contact me personally at mark@realestatelawyers.ca or by phone at 416-702-2499. Thank you.